power to quash Basishora having regard to the peculiar circumstances of each ruling.
The Supreme Court has quashed the decision of the High Court. After the December 7, 2024 election, there were some issues with the result in 9 constituencies, which led to challenge. The presiding officers in each of these areas declared the results and announced the winners. But then, the Electoral Commission stepped in and said they needed to recollect the results. This decision was made within a week of the initial result being announced. However, the Supreme Court has now overturned the recollation of results in 4 of these constituencies, especially Okankwe Central, Ablekuma North, Tema Central, and Techima South. The court cited that the High Court initial order was unfair and did not give the NDC candidates a fair hearing. The Supreme Court has ordered a rehearing of the case, which is set to take place on December 31st. This means that the results in these 4 constituencies are no longer valid. The case will have to be re-examined. If today is your first time of joining us, we are excited to share in-depth analysis and insightful discussion on trending issues. Subscribe for more updates and join the conversation.
By the NDC.
Yes, you make the point and let's see if it will help us locate.
Okay. My Lord, in the said exhibit, the applicants had applied for judicial review, whereupon they have indicated that there have been declarations in their favor with video evidence of those declarations. With video evidence of those declarations.
Yeah, but those were not before the judge who determined the mandate.
They were before him. My Lord, they were before him. Yes. I stood up. Yes, my Lord. That's the unique thing. I stood up and brought to his attention that, my Lord, pending before you is this application. So we even found ours on the 16th. On the 16th of December, this mandamus application was filed on the 17th. But my Lord chose to hear the mandamus that was filed on the 17th. Yes. It was in the court and before him.
Please, the two are not the same. Okay. Was it pending in that court or it was right before him?
My Lord, it was pending.
Say so.
And it was hearing that same day.
Or it was listed for hearing?
Yes, that same day. So I stood on my feet and drew my Lord's attention. But my Lord, these are declarations with video evidence. So consider my application first. He ignored it.
I lost respect.
Yes,
you see, some of the facts being heard in this court are indeed erroneous. They are erroneous. And I think it's fair that I put them in context. Okay. The process he found.
Counsel, you can read.
No, just hold on. Please. What he found was not before the judge. It was not before the judge.
No, it may not be on that docket.
Was listed.
It may not be on that docket, but it may be in a separate docket.
No, he came to court holding the documents.
No, we're talking about the second application. Or the first application, the one they filed on 6.
The one they filed.
The first application. Okay. So, Mr. Tamaklo,
yes.
Continue.
So, my Lord, at the time my Lord considered, he had before him video evidence And in fact, when I brought it to the attention of my Lord, he indicated in open court that the docket was just brought to him the evening. And in fact, that application, I moved it together with my learned senior. After he had granted the mandamus application, he now asked me to call that.
Oh, okay. So he heard it?
Yes. In fact, I even made a prayer that, my Lord, I beg you, watch the videos. He said he will do it, and started giving his ruling.
Decided to exercise our discretionary power to quash Basishora, having regard to the peculiar circumstances of each ruling. Consequently, we hereby quash the orders of mandamus made for collation of results by the Electoral Commission in the following constituencies: 1. Okaikwe Central, 2. Ablekuma North, 3. Tema Central, and 4. Techiman South. Accordingly, the collation of results in the above constituencies by the Electoral Commission after 20th December 2024 on the orders of the court are hereby set aside. The time for filing is hereby abridged. Circumstance of time constraint on the national electoral calendar, we hereby abridge the time for the hearing of the mandamus applications in the High Court and direct the High Court to hear the applications for mandamus on Tuesday, 31st December 2024.
The true mandate of the people will still stand. We're grateful to the courts for heeding our requests.
We're happy that our confidence in the law has, borne its fruits, and we're happy to go and continue. I think it's important that everybody understands that this is just the beginning of our work. And I think that this experience equips us to be able to represent all our people a lot better.
And then I think it redeems the image to an extent of our courts and our judges. So it's all well and good.
The court said it's a fundamental rule to be heard. So go back to the court and have your matter heard. So it's simplicity. We are going back on Tuesday. They will file their response. Okay, on why they think that there was collation or there was no collation. The court will hear the matter, make an order for EC to go and make collation and a declaration.